We're in for an interesting session this afternoon. I'm going to ask David if he can go forward. David, do you want to speak from there or do you want to speak from there?
I've been told that I should speak from there.
Speak from there, please. Yes, thank you very much.
Well, thank you all for coming back. I'm delighted to be part of this symposium. The subject of my remarks will be how ideas about the proper role of international human rights in criminal procedure law in the United States and the United Kingdom are related to ideas about democracy. The argument I'm going to make is that to understand much of the growing opposition to international human rights as a source of criminal procedure rights in the United States and in Britain, you need to see that opposition as rooted in a certain conception about what democracy means. The conception it's rooted in could be called popular sovereignty. Popular sovereignty is not the same thing as populism. One's a form of democracy. One is a form of theory of democracy, and the other is a form of politics, but they are allied. There's an alternative conception of democracy, which I'll call democratic pluralism. And just as popular sovereignty is related to populism, but isn't the same thing as it, democratic pluralism is not the same thing as anti-populist politics, but it's congenial to that form of politics. And if you take a democratic pluralist perspective, I'm going to say, the case for incorporating international human rights in domestic criminal procedure regimes becomes much stronger. So let me start by describing the current debate in the United States about the role of foreign and international law in criminal procedure. For about 20 years now, this has been a topic of great dispute in opinions of our Supreme Court. A key moment in that debate was the Supreme Court's decision in 2002 in a case called Atkins versus Virginia. The issue in Atkins versus Virginia was whether the provision in the United States Constitution that prohibits cruel and unusual punishments was violated by Virginia executing mentally retarded defendants. The U.S. Supreme Court said that it was violated. The majority opinion was written by Justice Stevens, and one of the things he pointed out was that within the world community, the imposition of the death penalty for crimes committed by mentally retarded offenders is overwhelmingly disapproved. You might be interested to know that in making that point, Justice Stevens relied on a brief filed in the U.S. Supreme Court by the European Union. Anyway, Justice Stevens made this point in passing in a footnote toward the end of his opinion, but it set off alarm bells for three dissenting justices, Chief Justice Rehnquist, Justice Scalia, and Justice Thomas. Writing for all three, the Chief Justice said it was completely irrelevant what other countries decided about the punishment of their citizens. The question was whether capital punishment for mentally retarded defendants violated American standards of decency, or whether, on the contrary, the practice was accepted among our people. And Chief Justice Rehnquist linked this point to a defense of democracy. The best measure of what our people accepted, Chief Justice Rehnquist said, the only reliable measure of what counted as cruel and unusual punishments for Americans, was what elected representatives of the American people enacted. Judicial fiat, he said, shouldn't be allowed to overrule the workings of, quote, normal democratic processes, by which he meant the laws enacted by state legislatures, including the laws in the 19 states, including Virginia, that authorized the execution of mentally retarded defendants. The arguments advanced in Atkins versus Virginia for and against the relevance of foreign and international law and criminal procedure are echoed in many other decisions of our Supreme Court. Often foreign and international decisions wind up being dismissed as irrelevant. That happened, for example, in 1999, 2 years before the decision in Atkins, when the U.S. Supreme Court refused to consider a constitutional challenge that had been brought by a capital defendant who was arguing that the decades of delay in carrying out his sentence would make his execution intolerably cruel and unusual. Dissenting in that case, Justice Breyer noted that a growing number of courts outside the United States, including courts that had accepted or assumed the lawfulness of the death penalty, had nonetheless held that lengthy delay in administering a lawful death penalty rendered ultimate execution inhuman, degrading, or unusually cruel. And Justice Breyer cited, among other things, a decision of the European Court of Human Rights, finding that delays in carrying out death sentences barred extradition of a defendant to the state of Virginia for a capital trial, even though the European Convention doesn't bar the death penalty. Breyer said that it was relevant and informative how foreign courts had applied standards roughly comparable to our own constitutional standards in roughly comparable circumstances, particularly since our nation's founding document, our Declaration of Independence, declares at the very outset our decent respect for the opinions of mankind. But Justice Thomas, who concurred in the Supreme Court's decision to deny review in that case, stressed that there was no support in American constitutional tradition or in the precedents of the U.S. Supreme Court for the defendant's claim. In fact, Justice Thomas said, the very citation of a decision by the European Court of Human Rights and the citation of decisions by the Privy Council and by courts in India, Jamaica, and Zimbabwe, all of that showed that there was no real support for the defendant's position in U.S. law, because if there were, there'd be no need to cite cases for abroad, he said. A decade after that, the Supreme Court ruled in a case called Graham versus Florida that the constitutional ban on cruel and unusual sentences prohibited life sentences without possibility of parole for juvenile non-homicide offenses. Justice Kennedy, who wrote the majority opinion in Graham versus Florida, pointed out that a strong international consensus had emerged against sentences of that kind. But Justice Thomas dissented, and citing Justice Rehnquist's opinions in Atkins versus Virginia, the case about the execution of mentally retarded defendants, Justice Thomas argued that both the foreign and international decisions cited by the majority in Graham versus Florida were irrelevant to the meaning of the U.S. Constitution, and that by relying on such decisions, the Supreme Court was illegitimately interfering with the ability of voters to decide through their representatives how juveniles convicted of non-homicide crimes should be punished. Sometimes in the United States, opposition to reliance on foreign international sources in criminal procedure law is linked to the idea that the Anglo-American common law tradition differs fundamentally from the legal traditions of civil law countries, and that therefore principles that make sense in the latter countries don't make sense in the U.S. So, for example, in 2006, the Supreme Court ruled in a case called Sanchez-Llamas versus Oregon that defendants in U.S. criminal cases forfeited their claims under the Vienna Convention on Consular Relations if they failed to raise those claims at trial. Now, a bit of background. The Vienna Convention on Consular Relations requires that foreign nationals who are arrested have to be told that they have the right to have their consulates notified. In the 1960s, the U.S. joined the Vienna Convention on Consular Relations, and we also joined an optional protocol giving the International Court of Justice compulsory jurisdiction over disputes arising out of the interpretation or application of the convention. The problem is that foreign nationals arrested in the United States are rarely notified of their right to consular notification. And the Supreme Court ruled in Sanchez-Llamas that they forfeit the right to complain about that if they don't complain about it before or during trial. Even if the reason that they don't complain about it during or before trial is that the defendants and their lawyers aren't aware of the issue precisely because the government has failed to comply with the notification requirement. Now, that was an awkward decision for the U.S. Supreme Court to make because the International Court of Justice had earlier ruled that claims of arising under the Vienna Convention on Consular Relations cannot be deemed forfeited by a defendant's failure to raise them, at least not in cases where the failure to raise the claim is itself attributable to the state's failure to inform the defendant and his lawyer about the right to consular notification. So, writing for the majority in this case, Chief Justice Roberts said, the International Court of Justice's contrary decision was entitled to respectful consideration, but it was just wrong. It was wrong because it overlooked the importance of procedural default rules in an adversary system. Procedural default rules, Chief Justice Roberts explained, generally take on greater importance in an adversary system like ours than in the sort of magistrate-directed inquisitorial legal system characteristic of so many of the other countries that are signatories to the Vienna Convention. And, by the way, decisions of the ICJ are going to carry even less weight with the Supreme Court in the future because while the Sanchez-Lamas case was working its way through our court system, the U.S. withdrew from the optional protocol to the Vienna Convention on Consular Relations that gives the ICJ jurisdiction, mandatory jurisdiction to decide disputes arising under it. Now, I've gone into detail about these U.S. cases to illustrate the heavy reliance that opposition to the use of foreign and international law in U.S. criminal procedure cases places on certain ideas about democracy. Reliance on foreign or international decisions is frequently criticized in Supreme Court opinions as anti-democratic for two reasons. First, foreign and international law doesn't express our values and our traditions, the Supreme Court says. And second, as I've noted, the Supreme Court often argues that giving effect to foreign or international decisions blocks the ability of the American people to decide for themselves through their elected representatives how they want criminal law to operate in the United States. Now, these two arguments probably sound familiar to you. They're the American version of the ideological backlash in the UK to decisions of the European Court of Human Rights, something that Paul Roberts spoke about this morning. And the point I want to make is that these ideas draw strength from a particular conception of democracy, what I've called popular sovereignty. The main idea of popular sovereignty as a theory of democracy is that in general, government should carry out the popular will. Whether something counts as democratic depends on whether it is what the people want. So democracy is understood as a kind of conveyor belt or assembly line. It starts with what the people want, and then it turns it into policy and practice. And the main thing you need to worry about under this view is that the conveyor belt or the assembly line will break down, that there will be agency failure, because elected representatives will fail to do or will be prevented from doing what their constituencies desire. Now, you may also worry that sometimes the assembly line will work too well and that the people, through their elected representatives, will act contrary to their best interests or will run roughshod over the interests of minority groups. So you might put some limits on the conveyor belt or the assembly line, but you will do that reluctantly and only at the margins, because for the most part, the people getting what they want is what you mean by democracy, if you have what I've described as a populist conception of democracy. Today, I think the most important rival to a popular sovereignty conception of democracy is democratic pluralism. This is a view that starts with the idea that there's no such thing as the people, that a nation is comprised of lots of different kinds of people and different groups of people. And so there's no such thing as the popular will. The populace contains lots of different wills. Furthermore, these many different wills may themselves not be pre-existing or pre-political. They may themselves be the product of politics. So the pluralist conception of democracy doesn't see democracy as a conveyor belt or assembly line, transforming a pre-existing will of the people into policies and practices. Instead, it takes democracy to be a process through which people of different backgrounds, different values, and different views can govern themselves peacefully and equitably. Different conceptions of democracy make sense at different times. If you think that the chief threat to democracy at this present moment is a form of exclusionary populism in which the idea of the people is weaponized to whip up prejudice, demonize political opponents, and legitimize authoritarianism, if, in short, reifying the people seems to you an increasingly toxic rhetorical practice, then you're apt to be uncomfortable with the popular sovereignty conception of democracy, and you are apt to be drawn to democratic pluralism. That's why I suggested that democratic pluralism is, at this time, the most important rival to popular sovereignty as a theory of democracy. So I think it's important to understand that under a pluralist conception of democracy, incorporating international human rights into domestic criminal procedure doesn't raise the sorts of concerns that it does under a popular sovereignty understanding of democracy. Because from a democratic pluralist perspective, the main point of democracy isn't for government to reflect and express our values and traditions, or to give effect to our will and preferences. A country is comprised of people with different preferences and different values, and democracy is how that diverse set of people govern themselves peacefully and fairly. So it isn't nearly as obvious from a democratic pluralist perspective as it is from a popular sovereignty perspective that relying on foreign and international law is anti-democratic. In fact, if the point of democracy is to allow people of different opinions and aspirations to live together peacefully and equitably, then international human rights law begins to look like it has particular democratic attractions. Because international human rights law is precisely a set of rules that have been hammered out by people of different backgrounds, different faiths, different languages, and different traditions to ensure fair treatment of all people, and to ensure that levers of government authority, including in particular the levers of criminal process, aren't used to silence dissent, to cow political opponents, or to oppress disfavored minorities. And those are precisely the kinds of consensual principles of fair and equitable process that you might think a pluralist democracy needs. So, it's not surprising that international human rights have become a battlefield in the widening conflict between populists and democratic pluralists. From the perspective of the first group, international human rights looks inherently anti-democratic. From the perspective of the second group, they're democracy enhancing. There's no neutral way to choose between these two different views of international human rights. It depends on what you mean by democracy and on what you think the chief dangers to democracy are today.